Hi, and welcome to CAM Resource Podcast, Episode 6, Protecting Our Property Managers. Hello, and welcome to CAM Resource Podcast. Today we are very lucky to have Meredith from Shutts Bowen. Meredith, would you like to tell us a little bit about yourself?
Sure. My name is Meredith Freeman. I'm a partner at the law firm at Shutts Bowen here in Tampa. My practice focuses on construction and real estate. I've done a lot of cases with associations, both in the construction arena, but also other things that deal with associations, including contracts and defended associations and all kinds of actions.
And also, she has defended management companies, which is why I asked her to speak with us today, because I wanted to do a podcast for management companies and managers. You know, it's so scary for managers out there. We never know what to do to protect ourselves. So I thought we could do a podcast just explaining what are some of the precautions that we could take for management companies, even though most of the management companies have their own attorneys. But what happens is when we own our own management companies, we get a contract and, we may get it in 1980 and then we don't look at it. And, it never comes into play until something goes wrong. And you forget to maybe update it so as court cases come about. So it's always good to review those. And maybe a couple of hints today might get management companies to review their contracts, to take it to their own attorneys or to you, whichever is best for them. And also managers. That's where we really need some help, because managers are always kind of in between. Either they're working for a management company, and management companies often have them sign forms, that they really don't understand, but we have to sign them or we don't. We're not for sure. And also, sometimes we're just employees of an association. So I thought today, if you don't mind, can we talk about that and figure out what are some good things that managers could look at and kind of understand. So I guess we'll start with management companies.
Okay.
What are some of the clauses you think are very important to have in a contract?
Well, I'm glad you had me talk about this topic. I think it is really important. I have been involved in a lot of lawsuits where managers are either the focus of the lawsuit or they're joined in with the association. And I've represented the management company a number of times. And the contracts become very, very important. So this is a very good topic. And I would say, just to kind of frame our discussion, some of the really important issues beyond the provision of the contract, just overarching issues are, is the contract clear? Are the intentions of the parties clear? That's one of the most important things. Is you have a contract that somebody else wrote, a lawyer, or you got it off the internet, and you may not understand what the contract is saying. A lot of those provisions that are talking about what you're going to do or what the association is going to do, those should be perfectly clear. They shouldn't be legalese, and you should really understand them. And really, you shouldn't be signing it if you don't understand what it says. So I think focusing on, are the intentions clear, is a critical piece to reviewing your own contract and knowing that it's going to protect you from things that may happen going down the road. The other thing that I've seen is it's important for the contract to be tailored for that particular property manager. Sometimes you have a cookie cutter situation where you just grab a contract off the internet, or you just use one from, that you got from a friend or something like that, and it doesn't really fit your business. Mm-hmm. A property manager that has a few properties is not the same as a regional property manager, property management company with hundreds of employees. So you need it to fit what you're doing. And you were just saying sometimes you don't read it for years, you get to dust it off. It should grow with you. If your company is growing, then the provisions in the contract may change over time. So that's super important as well. Do you want me to talk about provisions specifically that I've seen?
Yeah, maybe, is it indemnification? Did I say that right? Probably is it one of the most important clauses, or can you explain what does that mean?
Sure.
And what is that?
Indemnification, it is a critical piece of the contract, in every contract, not just property managers, but essentially against the association for a fair debt violation. And a manager is named in the lawsuit. Well, maybe the manager is just acting under, they should be just acting under what the board is telling them to do. But nevertheless, they're a party in that lawsuit. So if they're in that lawsuit because of what they're doing for the board, because of what the board told them to do, they should be protected by the association. So that's why you want a strong indemnity provision in the contract that will protect you if that happens. And I'll tell you, it does happen a lot. There's a lot of times when, you're just doing your job and you get served with a subpoena and it's a lawsuit and it really doesn't have a whole lot to do with you. You still have to hire a lawyer. You still have to file an answer. And so, that could really be devastating for a smaller company to have to defend those lawsuits where they really haven't done anything but their job. They're just kind of caught up in the mix because of what they're doing for the association. Now, that one is a provision where you're going to have some legalese and there are legal implications. So if you're not a lawyer, you do have to defer to some degree to a lawyer to guide you on that, but you should make sure that it's in there. You should make sure that you have that protection in there. And another one that goes hand in hand with that provision is insurance. There's a lot of focus on what the manager should have as far as insurance, but does the association have insurance in place? So if that exact scenario happens and you've got the strong indemnity provision in your contract, are they going to have the insurance that pays for your defense? Because that's critical. I mean, what's the point of having that indemnity in there if there's not immediate funds to pay for the defense?
And we have personally seen it where the insurance company has saved the day, thank goodness. So whether you're an individual manager or a management company, one of the first things you should do when you take over a property, zone in on their insurance policies. See what their D&O, their crime policy, is that where that would come into play, is the crime area? What section of the insurance should they really make sure that they're included in?
Well, my advice on that would be sort of stay in your lane. You're a property manager, not an insurance agent. So yes, you should do a review of the insurance policies. You have a discussion with the board about their insurance policy, but you should also have someone in your corner who is very familiar with what associations need. Those laws change, they're up to date, and hopefully you're getting some of that information in your continuing education, but you also want to have someone on board with you and helping the board to make sure they have everything they need that is an insurance professional. So
good insurance agent.
Yes, I think that's critical for managers to have, among other professionals that they would want to be working with. For example, an accountant. The books and records need to be audited. I mean, that's not necessarily the manager's function. You need to obviously do what you're required to do as a property manager, but there's also professionals that, where there's some overlap, but you don't want to get too far into those zones where you really do need to be a licensed insurance agent to be, giving that type of advice. So yeah, I would say that all kind of falls under like indemnity insurance. Those are very important provisions you should spend some time on. You should be talking to a lawyer about. You should be paying attention at continuing education of what's happening in the industry as far as those provisions. But absolutely, they should be in there and they should be addressed in every contract.
And make sure you have a good attorney, and hopefully the attorneys had some experience with actual litigation, because that's where the real education comes from. Is okay, well, when you're in that courtroom or when you're actually defending, what are the crucial parts of the contract that were weak or strong? So that kind of helps a lot too.
And that's really the perspective that I'm speaking from is, what have been some of the provisions that have been problematic when we get to the litigation and we have to kind of test those provisions. I'll tell you another one that comes up a lot, and it's again one of those sort of overarching things is, in your documents and the articles for the association, the articles of incorporation, they'll have in there powers and duties of the board of directors and those things that the board is responsible for doing, and they have a duty to the membership to fulfill those duties. Sometimes management contracts are worded in such a way that it appears that the property manager is taking over those responsibilities. And I don't like to see that. I think it should be that they're assisting the board in doing what they're supposed to be doing, that they're preparing documents, that they're providing a service that is helping the board fill its duties, not taking over that responsibility. And so sometimes the wording will be in such a way that it kind of makes you cringe, like, well, they're not a board member, they're a property manager, and so they don't have that particular duty. I can give you an example, like preparing and approving the budget. That's a function, or approving the budget is a function of the board of directors. Of course, a property manager needs to assist and can even prepare it and, submit it.
A proposed
Budget to the board of directors, but actually approving that budget is a function of the board. So you don't want your contract to say that you'll get a budget passed, because that's not what you're going to do. You're going to prepare it and you're going to submit it to the board for their consideration. And so you don't want to have a contract that's sort of overstepping those particular duties.
And one thing I've noticed a lot, I've been on all sides, management company side, manager side, and I've noticed that a lot of times what happens with management companies, they're so eager to take over a property, which is good because, hey, that's how we survive. But what happens is once they get in with the initial contract, other things spin out of there. And what happens is sometimes we don't add that into the contract. Let's say we're doing extra accounting for that reason, and there's no, you can be sitting down with the board and going over it, and they're all like, yeah, just go ahead and do it. But you really need to get that in writing, that little bit of extra, because board members change. You can be in the middle of a contract and have one whole set of board and a whole nother set comes in, and then all of a sudden there's not that clear instruction in writing signed by everybody that needs it. My husband's in construction. I always tell him, make sure you get those side orders signed, and he, because it's so important, because later the person approving the invoice may be somebody totally different. So it's good to remember that even though you take over and you're eager to please, make sure that it's real clear in writing on what extra work you're going to be providing.
And that, I think that's a super important point, and that always happens, during litigation. Even you get the change in the board of directors, and nobody remembers approving this, or nobody remembers, where this was discussed, and it's not in the meeting minutes. And I would say just one thing that people don't do intuitively that could really help is pull out the contract. How do you do an amendment to the contract? There may be something, there probably should be something in the contract that says, it has to be a writing signed by both parties, right, or it doesn't change the terms of the contract. So if you're taking on additional duties, how much are you going to be paid to do that? Is this going to be something that, you're going to just wrap into what you're already being paid, or have they agreed to pay you above and beyond your contract to do that? If they've agreed to pay you, you certainly need to have that spelled out in writing in an amendment to the contract, or whatever the contract says as far as that needs to be done to change the contract. There are clauses, they're called integration clauses, where it will say essentially you can't have an oral agreement that will change the contract. It has to absolutely be in writing, or it's not effective. So we get to litigation. I mean, it's when everybody's getting along, it's fine. You're getting paid even though it's not spelled out in the contract. But then once it's in litigation and you have a new board, you're not going to be paid for that.
And that judge only sees what's in writing, so that's why it's so important. Even goes for individual managers. So just a second, I don't know if we can slide over to that, but even whenever a manager is interviewing for a job, sometimes it's negotiations. You're, going back and forth, and what'll happen is you may be interviewed by the president of the board. And you ask a question as a manager. Oh, do I have Sundays off? Oh, yes, you'll have Sundays off. Well, that's not in writing somewhere. And now all of a sudden that president's gone, and somebody else's president said, oh, no, you have to work on Sundays. Well, get that in writing, even if you don't have a contract as a manager, which I think, Meredith, you do recommend.
Absolutely.
Okay,
Absolutely.
Which we'll go into detail about that in just a minute. So we do recommend it, but even if you don't, for some reason, because I know it's confusing sometimes, just make sure that whatever is being stated right there is in writing. Just say, oh, that's great that I can have Sundays off. Would you mind we'll just put all these things in writing and you can sign it just before, we end this.
Yes, and I'm a litigator, so I always go to extremes on these things. The other thing that comes to mind is the provisions in your contract. How do you get out of it?
Right.
If you say, I need Sundays off, and that is just a deal breaker for me. I need that day. I work 6 days a week, and I need Sundays off. And they agree to it, and you come to find out that is not the case. They're not going to give me my Sundays, and it's just not worth it to me. How do you get out of that contract? So you need to have something in there, again, tailored to your business that you think is appropriate on how you terminate the contract if it's not working out. It's such a personal relationship between property managers and their boards and the people that they work with all the time. You you really don't want to be in a situation where you can't get out, or it's financially devastating for you to get out. And that works both ways, for the association and for the property manager. Know ahead of time, if this doesn't work out well, how do I get out of this contract? What are the steps? What needs to be done? How much is it going to cost? How much time is it going to take? So that makes you in a much better position to make informed decisions if there is something that comes up that's sort of a deal breaker for you, and you're thinking, this is really going to impact my business or my personal life, or I just can't get along with so-and-so on the board. It's, we're making each other's lives miserable. I just need to move on and do some other things. How does that happen with the contract that we all signed?
Yes, and as managers, whenever we're doing contracts for the associations, often we look at, a 30-day out no matter what, either sign. I know it sounds like, oh, well, I don't want to do that. I'll lose my job. But you know what? If people aren't happy, it's just the thought to, have that thought to say, hey, we'll have a 30-day clause. Either one of us not happy, we'll move on. So that's something to think about. But you do have to think about that situation in the beginning. And I know you don't want to think about that because it's negative, but you have to think about it. And especially in associations, they become political so easy. It's just the nature of the creature. It's just they're political. And, you have to sometimes really value what Meredith said. Sometimes you have to value and say, this job is not really worth my heart and soul right now.
That's right.
So let's talk about individual managers, because at least 50, well, I'd say, a good 30% of the managers out there are actual employees of the association. So Meredith, do you recommend that when you're being hired that a manager does have a contract?
I do. This kind of goes back to what I said in the beginning, is that you want your intentions to be clearly spelled out in what before you agree to do the job, and a contract does that. And sometimes, like the example that you gave about Sundays, people will agree, yeah, we can do this, we can do that, but when you put it down in writing, they're not so agreeable. So you need to make sure that everybody's on the same page, and that memorializes it. So I think in that instance as well, it would be better to have a contract.
So let's go through the real world, and you're a manager and you're unemployed, so that means funds are not always there. And, so I think a lot of times that's what happens with managers, is they don't have the funds to do a contract. So maybe, while you're working now and have income coming in, do that contract now and actually go to an attorney. I guess it wouldn't be, especially, now what's your thought on this? If someone pre-writes a contract and sends it to an attorney, is it less expensive than you having to draw one up, or how does that, because let's be honest, it's hard to sometimes afford an attorney.
I would say probably not. You're going to want to be looking for an attorney that has done these contracts before, and so they are going to have some sort of boilerplate form.
Are they? Okay, good.
That they could use. So they're really not starting from scratch for the most part.
Okay.
And then the most important part of the process, whether it's you're doing it yourself or whether you go to an attorney to do it, is tailoring it for your particular situation. So there should be something to start with either way, and that you can work with. And I would say, worst case scenario, even if you didn't have an attorney, but you wanted to, sort of follow what I was saying earlier about having clear intentions, and spelling out, what everybody agrees to, what I would look at, and this is what I ask my clients, what are the biggest problems that you have? What problems do you face in your job? What has happened over the past that has really been troublesome for you? What problems have you seen your colleagues go through? Focus on those, because those are going to be the big things that are going to, potentially hurt your business or really put you in a bind, and make sure those things are addressed in the contract. It sounds like you're talking about somebody that's been in the industry and that maybe is going out on their own, or, they have some idea of some of the, the things to be wary about or the problems that they've had. And so that whether you're doing it yourself or whether you're going to an attorney, you should be focusing on those things in addition to that boilerplate that's in the contract.
And the worrisome about doing it yourself is you may not realize you may actually be harming yourself by putting the wording in there. And another
Yeah.
thing is as a manager, sometimes if we're being hired individually, we're a little intimidated of slapping down a contract because we don't want to scare them away. But really, if it's a good board, they would see that as a good thing because you understand contracts and that you know that that's an important thing. So I don't think it would be a bad thing I think overall, in the end of a relationship, it just goes so far to have that contract on both sides.
That's right, and they may not have an expectation either way. So if you're slapping down the contract and saying here's how I do business, they may be impressed with that, or they may think that that's just the way it goes. It's the first time I've been on a board, and this is what the normal is. So it really should be the normal, in my opinion. So I don't see any problem with having that contract prepared ahead of time and submitting it to the board and you can talk about it with them. And if they have questions or there's some things that are sticking points for them, you can go through those. But certainly to have one, I think is really important.
And I think a lot of individual employee managers think, oh, well, I'm an employee, I'm protected by all the employment things. But that's not always really true. The experience that I've had with Florida is there's not really that many employee laws that protect you. So that contract would go that little bit of extra way. And like I said, I think the most valuable thing is educating the board on what really your duties are. Often, especially in portfolio management, I see that board members just think you do everything. They just don't understand. So whenever that board does change over the years and they say, well, why aren't you doing this? You're our property manager. You can say, oh, well, that's not in my contract. And you put it in front of them and they say, oh, now I understand.
That's right.
So.
And I'm not an employment law attorney, but I think what you said is important about the laws in Florida are not going to address specifically, the employment laws are not going to address specifically the duties of the property manager. And so that's where they would fill in what the agreement is and what the expectations are for the parties. The other thing that brings to mind is another important provision in the contract is what do you need from the association, from the board of directors? Sometimes that's overlooked. You cannot do your job without access to records, without the ability to get decisions from the board.
Good direction, yep.
Yeah, you need good direction. You need to have an efficient process where payment can be made for the board. So all those things, the expectations that you have from the board of directors is super important as well. And it is much easier to say, you are required to do this because it's in the contract, rather than, please, would you do this?
Well, and also what we find is, you're hired by a couple board members that are sitting there, and next thing you know, now sometimes you just have board members that aren't involved, and you're trying to make these decisions. So I think one of the best things in the contract is to say who you receive direction from, because you could have anywhere from 3 to 11 board members, and if all of them just want to, tell you what to do at the same time, you have to have something that says, I take directions from, let's say, the president, and that's clearly written, and that will help sometimes whenever the politics start up. So that's one of the most important, and a lot of times as an employee, that's not addressed.
And I see that a lot in litigation as well, because when something bad happens, everybody kind of points, he did it, she did it.
Right.
And so if you're taking action from someone who is not the right person, that could be problematic. But if you have it set out, this is what I'm supposed to be doing, and this person told me to do it, it does give you some protection. That absolutely I did this because I was instructed to do it, and this is the person that I'm supposed to be taking instructions from.
And what happens a lot of times is sometimes the manager gets thrown in, a management company gets thrown in the middle. You'll have the political regime take over, and you're just caught up in the middle of it. So that's why it's extra special to have that there.
And that happens very quickly when somebody files a lawsuit against
Very
the board
quickly,
and the
everybody
manager.
runs,
Yeah.
and then you're sitting there going, wait, what happened? So, okay, so let's talk about, let's say I'm a manager and I just got hired on this fantastic management company and I'm very happy. I'm so happy I just have a new job. But really, I need to look at, as a manager coming in this management company, I also need to be protected as a manager. So what are some of the things? I know a lot of times when management companies hire managers, they have them sign a non-compete. Can you explain to us what is that and how does it affect us as individual managers?
Well, a non-compete clause is a limitation on what you can do if you leave the company. Essentially, the company is saying, I don't want you to come and work for me for 6 months, take all my procedures, take all my clients, and then go work down the road for another management company or for your own company. And so they're trying, it's not necessarily an evil thing, they're trying to protect themselves. Right. But at the same time, as a manager, you have to be careful because you've got to make a living.
Right.
So you can't have a non-compete clause that is so restrictive that you essentially can't get another job. And so that's where the rub is and where the balancing act comes in. And it may be good to get the advice of an attorney.
Yeah. Before you sign that.
Before you sign it, on the specific language in the non-compete clause, what does it prohibit you to do from doing? And you could be in a situation where you're excited and you really want the job, but once you really understand the provision, you're thinking, I can't do this because it's just too restrictive. And in that case, you should talk about it. You really should try to discuss it. I have a lot of people tell me in their own experiences that they picked up the phone, they called the person, they said, I really can't do this because da da da, and they explain themselves and they talk about it and they're able to reach an agreement that's not so restrictive but still gives the company some protection. The other thing is to have your lawyer call the other lawyer if it gets to that point, because they're used to negotiating. It's not personal at that point. They just say, hey, this is I don't think this provision will be enforceable, it's too restrictive, how about we try this language? And we do that all the time. So the biggest thing on those, I would say, is to read it and understand it, get advice of counsel if you don't understand it, and if it's unfair, what do you have to lose? At least try and address it. Right. and see if you can get language that's a little bit more balanced, so that you never know what's going to happen. You may need to leave the company, right. And you don't want to be in a position where you have to change careers essentially, because of this provision. And you also, it's not ideal to be in a position where you're saying it's unenforceable, so I'm going to ignore it, and you end up in litigation.
Yeah, and that's the main focus on this section of this conversation, is that you understand it so that you don't do something unknowingly once we leave for all different types of reasons. We leave because they lost the property, for political reasons, and then you really don't have a job. And it's important that you don't just unknowingly go out there and get hired with another company. Next thing you know, you have a notice saying that you've not complied with it.
And we're kind of talking about this in an abstract way. One of the things that I can think of that could be super important is the distance, for example. If it says you can't work anywhere in Florida, that should be a deal breaker in my view, because it's just going to completely prevent you from doing your license in Florida, and it's going to completely prevent you from doing your job. Now, if it says 5 miles, maybe you can live with that, because you could go 5 miles, one way or the other, and not violate the provision, and they can keep their clientele, and you can start your own, or go work for somebody else, and everybody's relatively happy. So the distance is always one that's usually discussed as being too restrictive or not restrictive, too restrictive or needs to be changed so that everybody can live with it.
Right. And so another thing that happens a lot as an individual, especially on-site managers, is they'll work for a management company, and the on-site property has it in their head that they could do it better themselves, because they all think that they can avoid this whole management fee. And so then they decide to go out on their own, and they want to take the manager with them. So that's where that clause is very important, to make sure, managers, before you do that, you read anything that you signed with your management company, because there's a lot of red flags there.
Yeah, definitely.
So, Meredith, is there anything that you've seen over the years that concern you with managers that you think is something that is worrisome, that they could be, have litigation about, or anything that you've noticed over the years?
Some of the things we've already talked about, but one of the things we haven't talked about specifically is what are you charging in your contract? What is included in most people have the management fee that they charge, that's kind of either a by door fee or just a lump sum that they charge, but then there's other items sometimes that are separate items. And so having a clear understanding and making sure that that's clear in the contract, I think is critical. And I've seen that go wrong on several occasions, where it's either a misunderstanding or it's just not clear in the contract, and the parties are surprised at the end of the day. The other thing I would say, it's maybe not necessarily legal advice, but just generally, is the personality issues that come up. I mean, a lot of times that's where litigation comes in, and it's just gone somewhere, it's gone sideways, and somebody's angry about something, and that is a situation where maybe that termination provision is important, where you can just shut the relationship down and go your separate ways in a professional way before it gets really bad. Because typically, if you have a misunderstanding over a contract or over what you're doing as a manager with the board of directors, that's not going to end up in litigation if there's a good relationship.
Right.
So it may be good in the long run, even though maybe in the short term it may be hard financially, to not keep those relationships that are either toxic or problematic for whatever reason, and move on to different ones. Because I think in the end of the long term, that may avoid you some headaches in litigation.
A couple of areas that I've noticed would be managers signing contracts. I can't stress more, and I'm sure you do too, that, like Meredith said earlier, it's the board that's actually running the association. We're the facilitator. But when someone puts their signature on a contract, it kind of changes everything. So even though we're an agent, and I know sometimes I am a manager, I have to sign every once in a while. I need to sign this $500 job to get this construction thing done. But the day that contractor hits a pipe and it turns into a $30,000 claim, and then somebody says, well, who hired those people in the first place? And even though you have a board told you or whatever, it's always better to get that president or someone on the board to sign versus your signature, because it really puts you more in the limelight. Is that correct? Am I right in saying that? Or?
I would agree with that.
Okay.
Absolutely. I mean, like you said, it's your business, and sometimes you have to make decisions in the moment, and a lot of times there will be a provision in your contract that will allow you to do that in an emergency, to take care of something that needs to be taken care of. But as a general practice, absolutely, it should be the board. And that can go back to what we talked about earlier, which is you need to have a board member available to do that for you in a timely fashion, to sign those contracts that have been pre-approved by the entire board of directors. Because it is, you think about it from the perspective of the person that you hired. They may not understand how associations work, and they have a contract that says your name on it or your company's name on it, and they think they have a contract with you. And so that if something goes wrong, that becomes a problem, because they are going to look to you and to your insurance to resolve the issue, and really they should be looking to the association, because that's who the relationship is with truly.
Another area that I've seen that I think is a worrisome area is construction jobs, or any jobs, especially the ones that are over a certain amount and need construction, the waiver of liens, the notice of commencement filed. We're hoping to do a podcast on this in the future. But I think that it's very confusing, and I'm on both sides. I've been a manager for years. My husband's a construction general contractor, but I'm still confused sometimes on who files that notice of commencement, how the waiver of liens are done. I do them all the time, but I think the general public is confused on that, especially managers. It's just hard to know who's responsible for that, but it's imperative that those are done in certain cases, and that who the contractors are out there on your properties.
And it is designed to protect the owners of property, and to make sure the contractors get paid. It's there for everybody's protection, but it can become very confusing. And I would say, one thing to consider is, especially in a large job, I don't know that you can take that on under your existing agreement as just another thing that you're doing. You really need to have a conversation with the board about what your role is going to be in this construction job, and how are you going to balance what you're already doing with these new obligations to help with this construction job, especially if you're not familiar with the statutes and what you have to do. There are professionals who are project managers who can be hired to make sure that there's a good contract in place for a job like that, who can help with the making sure all the releases are being obtained before payment is made, and give some protection. Also, obviously, lawyers can help you with that. Interpreting, when you get certain documents, there will be warnings on those documents, and it'll explain what will happen. Reading those carefully, but calling your attorney. Like I said before, as a property manager, it's good to have relationships with professionals, because if you do, you can pick up the phone and say, hey, I just got this notice to owner. What are the implications of this? What does this mean? What do I have to do? And if you already have a relationship with the attorney, they're probably going to answer your question.
Yes, and they do, yes. And that's why we do these podcasts, that's what I'm bringing to you is all the professionals that I'm lucky enough to have worked with. And so one of the biggest areas I see in a normal manager's job is paving. Paving is something that's normal. But those paving jobs can be anywhere from $50,000 to $100,000 easy. And those are the areas that I see as a big concern, because we do it all right. We go to the board of directors. We provide them all the bids. ABC Paving wins the bid. There's a generic contract delivered back from whatever, and the board signs it. And until I remember one paving job, everybody showed up and I said, well, where's your traffic control people? We don't provide traffic control. So understand those contracts. And I know it's hard because we're not professional pavers, but try to understand what are they going to be doing. And then that's whenever you file a notice. I've heard I've heard them say after I said, well, we need to file a notice of commencement. Oh, well, that's going to change everything. And it's like, well, why is that going to change everything? What's happening on the backside of that? And I can tell you many a times, you hire ABC Paver, and then all of a sudden you get a notice of owner for some company, I guess, providing the asphalt. All those companies need to file waiver of liens. And
Right.
so that's where it gets so confusing. And as managers, we're always trying to keep that price down low because we want to save the association money, and we only have so much in that reserve account. But, at what point do we veer off and say, hey, it's worth it just bringing in that? Sometimes it could be, to have that project manager could be another $5,000 to $10,000.
That's right.
So and then they, the board looks and, well, isn't that why we have you? So yes, in a way, but you also have to protect yourself, and that's where I've really seen a big worrisome area, and where we just do it. It's common, we do it all the time, but it's an area that could hurt us.
Well, and what is your experience on it? If you've done 5 of those and you maybe had a construction manager involved in 4 of them, maybe you can take it on. Maybe you can do it because you're familiar. You are able to keep track of those notices and make sure that you're getting the right waivers. But it can get complicated.
It is
and
complicated.
There's rules about what you can lien in condos. You can't. You just lien everything, and so it can get very complicated. The other thing to consider is the person that you're hiring or the company that you're hiring to do, for example, a paving job. Have they worked with associations before? Because that might be helpful as well, that they understand what rules they're dealing with and the dynamic that they're going to be dealing with the board and the property manager. It's a different animal. There's lots of people that are extremely competent in construction, but have never done projects for an association. Maybe they did it for the developer, which is a little different, but never done a project for an association. So it might be good to include in the bidding process companies who have done work for associations before and have that experience, and then also the consideration on the larger jobs, should I have a construction manager involved, how much is that going to cost, at least have them come in and pitch to the board and explain what services they provide and how they can help the association along with the project.
And also understanding all of the jobs that we have, there's so many different areas. There's painting, there's paving, and understanding what's the difference between seal coating and this, or what's the difference between different kinds of paints and how many coats. So it's good to look for your professionals at that time and try to understand it. So And another area that I see is very concerning and always an issue with managers and management companies and boards is the whole company versus employee versus workers' comp. So, it's important that associations seek that workers' comp information. And I know it's always, I have associations will say, oh, Joe's worked for us for years, and we don't want to lose him. And sometimes you're just going up against that. So at least if you don't have a company that has the workers' comp listed on their little liability, which when we talk about insurance, that'll be something. The workers' comp policy is very important, because if you just hire a little company that comes out there and they just happen to bring their cousin Joe to come out there work with them, even though the one person working out there may have a workers' comp exemption, their cousin Joe might not. And we know cousin Joe would never sue us, but if cousin Joe dies and his wife is looking like, I can't survive now, her easiest thing may be to sue the association. So it's very important to get familiar with those different aspects of what's a workers' comp exemption, what's a workers' comp policy, and make sure, especially that's where managers that work on the associations individually, management companies usually have a set assembly line, like, before they cut the check, they're going to get this. But sometimes managers that work on site don't always, and they're going up against a board who really likes Joe, who has worked there for a year. So there's a way you can still work with Joe, but just make sure that it's covered. And that is definitely worth an attorney to review, because let me tell you, the worst thing to happen is someone get hurt on a site, and then that's whenever you learn your lesson about it.
Yes, and back to the construction projects too, another thing, we talked about contracts for managers, but the contract for the construction project is critical too.
Yes.
There's been a number of times where, we're at litigation, we're already in litigation, not much can be done about the contract at that point, but you have a $1 million job with barely a one-page contract. And so you're thinking, if you're going to invest $1 million in improvements, or you've got like a parking garage situation, or something that's a huge project, you really need to consider investing in the professionals who can help you with that contract, including an attorney.
At least to take the onus off of you. I mean, our job is not to do all the jobs. Our job is to point the board in the directions of the correct professionals to do the job. Insurance agents, project managers, attorneys, that type of thing. So, because overall, we have to protect ourselves.
That's right.
We have to. And it's good for the association for you to protect yourself too. So it's important to spend that little bit of time. And I know sometimes we're so busy, and we just it's too complicated, but it's not too complicated.
And I would add, from my litigation experience, a lot of the time when you get in these lawsuits, it's because you did something above and beyond that wasn't in your contract. You were just helping the board out. You were just helping this board member out, and that's where you end up in trouble. And so, I'm not saying be unkind. Of course, you should be kind, but make sure that you're covered.
What is it? The road was paved with good intentions.
That's right.
So, and that is it. I can tell you right now from experience, that's what I've seen over the years is, managers really caring and just trying to help out. And that's whenever make sure, think about, okay, is this in writing? Is everybody, what happens if all the people that are involved right now aren't here?
Right.
Because that's a good chance that's going to happen. So let's again talk about insurance. So I'm an employee. Let's say I'm an employee on a property, and I'm an employee not through a management company. What are some of the things that I need to make sure that's covered for me? And I know workers' comp's one of them, so make sure that how the association needs to have that worker comp policy on me, correct?
Yes, the workers' comp for sure, directors and officers, of course, liability. There's a crime insurance fidelity policy that there's a statute on that needs to be looked at. There's a number of policies that you're going to want to make sure are in place. And you're talking about, you're the employee, but you're also the property manager. So you're going to be reviewing that and making sure that that's there. Yeah, and it is, in a way, you are protecting yourself to make sure that the insurance, that the association has the right insurance policies. But again, I would defer to the professional,
Yes, the insurance agent,
the insurance agent, to make sure that everything is there that's supposed to be there. And a lot of these policies are very standard. And one thing that is important, I would say, excuse me, about your insurance professional. Again, someone who has dealt with associations. It's a different animal.
100%, yep.
If you just go to an insurance agent that's done a lot of residential policies, you may not get as good as knowledgeable information as you will get if you go to someone who specializes in associations.
Same thing with attorneys. Attorneys really need to understand, because associations are a whole different world. And they need to know what are the pitfalls and what are the areas that need to really, and insurance, I can't tell you how many properties I took over and the insurance agents never even read the documents. In the documents, it tells what policies they have to have. That's sometimes. Right. So, or they don't even understand what an association is.
And the statutes in Florida, the documents and the statutes in Florida, and those statutes do change.
All the time.
All the time in association law, for whatever reason, they are ever changing, and not just little changes sometimes. Sometimes they're big changes. So absolutely, both the attorney and the insurance agent that are knowledgeable in association matters and knowledgeable and experienced in association matters, that is important.
And one of the areas that I see as a big area of concern with insurance companies is that when it comes to the knowledge of condominiums, especially when it's concerning leaks, your insurance agent needs to understand, what does the association cover, and that a lot of times that goes back to the governing documents, so that agent really, because if a homeowner calls or somebody calls and they're given the wrong information, it's so hard when a manager has to explain to a homeowner that, yeah, I know you had a leak from upstairs, but it's still your insurance company's going to cover a certain amount, and sometimes that insurance agent can help so much. And that.
Yes, I've seen a lot of litigation over what is a common element.
What is a common element, and does the drywall covered by the association
that's
or
right.
this? And that's when those laws change a lot too.
That's right, and it matters what the declaration says. It absolutely does. And getting professionals involved in those tricky questions. I will tell you, I've spent hours analyzing those questions, and I'm a lawyer, so it's not necessarily a simple, I'll just pull the documents and take 5 minutes and look at it. Sometimes it is a call to an attorney when there's a leak, and let's figure this out, and making sure that you have the right coverage. What you don't want is for no one to have it covered. Yeah. That's where the problem comes in. Because
everybody's looking for something. They don't have the money, and they're looking, and that's whenever it gets really hairy. And also as a manager, whenever you first take over, look at those documents and you understand it. Even if you have to go to the board and say, look, I know you've been doing this for years and you pay for this area, but I'm reading the declaration and I'm thinking, I'm questioning it. Even say, hey, it's worth that one-time expense to call the attorney and say, look, what are we supposed to cover?
That's right.
Because, oh man, it's just, you don't want it to be during a leak, because you're going to have to get that water cleaned up fast, and who's going to pay for those fans, and who's going to do this? So it's worth it whenever you first get in there and determine who does what ahead of time.
And then you'll have the letter in your file from the attorney that says that here's where the responsibility is of the association, and you've fulfilled your obligation as a board to evaluate what your responsibility is, and then you've gone and gotten the appropriate insurance. Absolutely.
Yeah. So, well, can you think of anything else we need to scare our managers and management? We're not here to scare you. We just want to protect us all.
No, I think we've pretty much covered it from my perspective.
Great. Well, maybe sometime you can come back and talk about the whole construction side, because that's definitely a whole podcast.
Oh, I'd love to. And thank you so much for having me. This was a lot of fun.
It is. Thank you. And we appreciate you being here, and look forward to seeing you or hearing you again on a podcast. And have a good day.
Thanks.
This concludes episode 6. We hope you found it helpful and informative. As always, you can join us at camresource.info for more episodes, or go to our YouTube channel, Cam Resource. See you there.
Join us next episode where we'll be learning how to manage community painting projects.